This is GRL Raw, the podcast where the GRL team tells you why they're different. Who the hell are they? Why should you want them fighting for you? The industry leader in law with over 180 years of combined experience. This team is here to shed light on crucial topics in law to keep you aware and informed, because it comes back to the primary point. We give a damn.
Welcome to season 2 of GRL Raw.
Cheers.
We did not get canceled.
We didn't. And we have permission to be here from everyone, I think.
It is amazing.
Yeah.
Corey's on vacation, so he may not know, but
Fair.
this is our second go of it. We're up in our game. We've made some big goals for this podcast.
Mm-hmm.
A lot more research.
Yes.
A lot more preparation.
Yep.
Even though we were trying to limit that.
Trying to limit the preparation.
We were trying to limit the time commitment, and then we got sucked in and we realized, hold on, there's a lot more to this and that we can have a lot more fun with it and hopefully get a lot more information out there that people can find useful.
Yep.
So the theme that we're going to focus on this year is what?
Defiance.
Defiance. That's a great word.
It is a really good word.
And in talking this through, coming up with it, it struck us square in the eye. It smoked us right in the face as we were trying to figure out what is a common mentality and attitude that we have here that crosses the boundaries of criminal, civil, personal injury, whatever it is that we have, what really drives this group. And defiance was the one. I mean, looking back at my life, that's me. That's where I'm at.
Same.
I assume you're the same. I know the rest of the crew's the same way. And it's fun. We again, high level research here. We came up with the definition of defiance.
What dictionary?
Google. You want to read it?
I can do that.
Yeah.
Full of or showing a disposition to challenge, resist, or fight. Full of or showing defiance.
Bold, or is that impudent? Was the other word? And because that's what we do. We love. We're the annoying. I don't know, not thumbing our nose, but if you do that, act like you're
like the class clown, but like with a purpose.
With the purpose, and more importantly, it's don't run around. What really motivates us is authority or perceived authority, trying to throw their weight around and then responding with, well, that's because we can. Okay, you want to motivate this law firm, you want to motivate people who work here, say, because that's how we always do it, and that's just fine. That's when the gloves come off.
Yes.
So we're going to have that theme for every episode.
Yep, the gloves
year.
Are coming off.
Gloves are coming off. We're throwing haymakers. We're going to have fun with it. And we're going to talk about, we are going to bring in some current event discussions.
Yeah, I think maybe we call it like trending. What's trending? Yeah.
Okay, that's Gen Z, right?
Yeah. Is that what we figured out? Is it Gen X or Gen Z?
I don't know. You're one of them.
I know. I apparently figured that out last time we recorded.
Okay, so we're going to have a current event discussion talking about trending topics, do our own little research, talk about them. My all-time favorite, or my new all-time favorite, since it's a whole season 2, is we're going to have a golden quote of the month.
From clients, other attorneys.
From real cases, real people, not made up, not pulled off the internet, pulled directly from videos, body cam videos. We take submissions. If people have a good one and want to send it to us, we will use it and give credit where credit is due. But we also fact check it if we think you're full of it.
Unless it's like really good. And then you're like, it doesn't really matter.
Then we'll adopt it and use it. Do's and don'ts
Yeah.
made the cut.
Absolutely.
So we're gonna have you every single episode again. And then a fun little addition is we try to focus throughout the year on some historical Iowa-based, Iowa-brought cases that were either at the United States Supreme Court or the Iowa Supreme Court, things that made a big difference nationally and locally as well. We're going to go into some background and some history. And then at the end of every episode, our goal is to have action points, where we're laying some things out of, we went through all this, and here's how you can use it.
Yep. If you relate to these things that we've talked about, these are the next steps.
Correct.
Or how to get a lawyer involved.
Yep.
What to do before you get a lawyer.
Yep. Some ways to set things up, the way to make sure things go correctly. Because I think each of the topics, we've even pre-planned topics. Like we're on top of.
I think we tried to do that a little bit last time, but things move. That'll probably happen.
It is a learning experience. And so with that, we start off season 2, episode 1, with the hottest trending legal case currently pending in 2023.
Yeah. No doubt.
No doubt. In fact, Johnny Depp is old news.
Nothing compared to this one.
Okay. What are we talking about?
We're talking about Idaho. And we're talking about Brandon Kohlberger.
Okay.
And you're going to tell us a little bit about what you think as a criminal defense attorney about that probable cause affidavit.
So they in the Moscow, we'll call it the Moscow murders. I'm sure somebody will come up with a more sensational name than that, where the 4 students were murdered in their house in Moscow, Idaho. They released to the public, because they haven't been talking much about the case at all, the probable cause affidavit that is I would assume it's like Iowa's preliminary complaint. It's the initial charging document that says, here's why we think we have enough to arrest and charge this dude with 4 counts of murder.
And burglary.
Oh, they added did burglary. Have they done anything with the death penalty yet?
I don't know if officially, but I think the prosecution's office has come forward and said that they're going to be pursuing the death penalty.
Not surprised.
Yeah.
So we got that. We went through it. You got some information. Start into it.
Well, with the affidavit, I read through it as a 25-year-old girl, and I will say this is not a normal probable cause affidavit. We don't have probable. It would be like a criminal complaint in Iowa. Usually there are a few sentences. Sometimes they get crazy and like a paragraph and a half. And then you're like, wow, this is wild. I know everything I need to know.
Yeah.
So this is not a normal affidavit, but it's regardless of the truth of the contents or if that's what the evidence ends up showing, it paints a really terrifying picture.
Oh, it's a movie.
Yeah.
100%.
It's scary. But they go through different phases of the investigation. It was interesting because they didn't talk about the investigation on the news, which is how it should be.
That part they did very well.
Yep. And then we find out later on that they had him as a flagged person of interest, potentially due to his vehicle at Washington State University. So they've been watching him for a couple of months.
Yep.
So one of the big things I think that we obviously need to talk about is how they flagged him down, which was the car. Ish.
So so a couple things that struck me as I'm watching this.
Yep.
First, maybe the guy did a great job or gal did a great job, but the person signing off on the probable cause statement has an entire 4 years of history of experience. Now, there was a lot of other resources put into that, but that's something that struck me. But yeah, the vehicle, this is a classic example of the ability of law enforcement to harness cameras.
Yes.
Cameras that record public activity that are going on in broad daylight, in the middle of the night, webcams of the food truck.
Yep.
There was a bunch of things where they just
that was a live stream of a Twitch.
On Twitch.
Yeah, which is primarily for gaming.
Right. Well, they're twitching. Apparently, there is a food truck that twitches their food truck action in Moscow, Idaho.
Yep.
And that's how they pieced together the time frame of when the victims got home.
Yep.
Where they were beforehand. Of course, they had all been out on the evening.
They were out.
They were out on
late.
Moscow till like 2 a.m, doing what college kids do. But so the vehicle thing, they pulled camera footage from these different cameras.
Yep.
And came up. They sent it to the FBI for help, and the FBI, claims that the vehicle matched the general description, though, of a white Hyundai Elantra.
Yep.
With between 2011 and 2016.
So another interesting thing is when they first came out to the public, they had said, I think it was 2011 to 2013, and then changed.
They broadened it.
They did broaden it. So that's an obvious cross-examining point, I would suppose.
I would think so. And then there was a license plate issue, 1 license plate versus 2 license plates, which allowed them to claim that, well, it was initially, and I believe the suspect's vehicle was initially registered in Pennsylvania, which only gives 1 license plate, and then was registered after the event in Washington, which gives 2 license plates. Yep. And Idaho gives 2 license plates. So they use that. Again, very general. I would say at this point, as a criminal defense attorney, you're like, you don't have a license plate number.
Yeah.
You don't have a definitive make and model. But then, again, this is a digital case.
Yeah.
They get in, and then, like you said, they get into the phone.
Yep.
Or phone information. What were your thoughts on that?
So we talked about this a little bit yesterday. The cell phone tower. Mm-hmm. My phone pinged to Kansas yesterday.
Did it?
After we talked about it.
Okay.
I was like putting in my Apple ID for New York Times. I needed to read a super pressing New York Times article last night. And it pinged to Kansas. Do you trust this cell phone logging into your account? And I sat there and I was like, well, we did just talk about that today.
But before we talked about it, what was your initial reaction to the cell phone information? What was the cell phone information?
Well, the cell phone information that they're giving out, or that was in the probable cause affidavit, shows that the cell phone was in the area several times before the night of the murders and was in the area the night of the murders and then turned off. Okay. Lost service.
My favorite is the words that you got to look at the words they use. They make a difference. The phone was utilizing cellular tower resources that serve Moscow, Idaho.
Yep.
What in the hell does that mean? And that's where we talked about, from the defense perspective, we know cellular tower resources you can get bounced from tower to tower to tower to tower before you are able to have that cellular resource. And so in the defense perspective, I'm looking at this. I'm like, Moscow, Idaho. How big is Moscow, Idaho? How many cell towers do they have? That's some things that you're going to want to know. Moscow, Idaho, according to Wikipedia, about 25,000 people population, 6.9 square miles. Now, looking at that information as well, the suspect is connected to Pullman, Washington. He went to school, PhD student in Pullman, Washington. How far away is Pullman, Washington from Moscow, Idaho?
Like 10 miles, 15-minute drive.
9 miles. 9 miles. 8.6 miles direct, but 9 miles. That's not far. That's from here to downtown?
Yeah.
Here to downtown Des Moines, from West Des Moines to downtown Des Moines. Not far at all. So suddenly we're feeling good. Maybe there's some things to work with. Cell phone towers aren't going to do it. Maybe he lost service. When you look at the probable cause statement, when service was regained with the phone was about another 9 miles southeast of Moscow. Not in between Pullman and Moscow. I'm betting that there is currently a feverish hunt for a murder weapon in that area.
Yes.
But so there's some things with that. But if you looked at it, what's the biggest damning evidence from that probable cause statement?
The sheath.
The sheath of what?
The knife.
The Rambo knife.
The Rambo.
Do you think it was our pedal bike guy? I wonder if it's pedal bike guy with the Rambo knife.
No, because remember he didn't have a sheath.
Oh,
that's why he kept getting pulled over, was because they said he shouldn't have an exposed Rambo knife on his pedal bike.
Maybe his sheath got taken by some college kids in Idaho. I don't know.
Too bad it doesn't say there's two different male DNA on there. Then we might know.
So what's the deal with the DNA?
There's one, I'm losing train of thought of how to say this. One male, what would it be called? One specimen, one
suspect.
One male suspect.
Comes back to one person on the button of the sheath, and then they go and they haven't matched it to him yet, but I'm guessing there's currently DNA analysis now that they've arrested him.
Yes. No, they connected it to him.
They have now.
Before, yeah.
Okay. So how did they connect it to him before, though?
They...
Look at it. This is so much fun. It comes
were
full
little raccoons in the trash. They did a trash rip to get the DNA.
They did a trash rip. We've been talking about trash rips all last year. And in this case, they go and do a trash rip in Pennsylvania of the suspect's dad's or parents' house.
Yep.
And then they use the dad's, what they believe to be the father's DNA, to trace it to him and the DNA on the sheath.
Yep.
That's a problem.
That's a problem for him.
But they may want to call Dope Yoda and ask about how to successfully defend trash rips. Right?
Seems like Pennsylvania might have trash rips for a while after this one. They might not lean into that.
It's not going to
with
help.
These circumstances. Helps a little bit when we're talking like drugs or...
So, and here's the thing that hit me too when we were talking about the trash rip thing is, for a defendant to successfully complain about evidence and how it's obtained as a violation, it has to violate their constitutional right.
Yeah, standing.
So would the defendant have standing to complain about the trash rip from his parents' house that matched his father that then connected to him?
No.
That's a law review article waiting to happen.
That is. Yeah, I guess I don't know.
Yeah.
And I feel like it might be more complicated because he's like home on Christmas break. Mm-hmm. Interesting.
Yeah.
But nothing the parents could do to challenge it. They're not the ones.
They can't suppress it on his behalf.
Yeah.
So there's a little mind twist,
Interesting.
Teaser. So
well, maybe Pennsylvania would take up a trash rip, but he wouldn't have standing.
Yeah, they got to call the Dope Yoda.
Dope Yoda's on his way.
Right. So quick, we'll wrap this up. What do you think's going to happen evidentiary-wise? What do you think what do you think we're going to come up with?
I mean, they're going to phone dump, Google searches, looking through Google history based on your Google account, which people might not know that, but your Google email, everyone I feel like has a Gmail account. Mm-hmm. How do you live in 2023 without a Gmail account? And it tracks your movement on the internet.
Yep.
So they're going to be looking for that, social media accounts. God, I don't know. I don't know much else. I mean, I think that there's like big talk about his major and that he's getting a PhD in full disclosure. I majored in the exact same things as him in college, and I would not be a proficient serial killer based on my education. Yeah. Which also, like, maybe he's not either, apparently, because...
If what they have... Yeah, I mean,
yeah. If what they have comes out at trial to play out as this story that was told in the affidavit. It'll be one of the like scariest, most horrific murders in the United States that I've lived through.
Well, if I'm defending it, I'm blaming the two people that supposedly saw it all and or that were eyewitnesses. I mean, who says they didn't do it? What'd you do to rule them out? All that fun stuff. If only this age group was millennials, we could call it the Millennial Moscow Murder. But I don't think they qualify.
No,
I think
they're
they're
young.
Gen
They're definitely
Zers.
Whichever one I am,
They're younger.
but because they're younger than me. Well, not that I remember, so that doesn't help. But
Okay.
yeah, it's interesting. Interesting. It's hard to. They painted a good picture in it. They did a good job with the telling a story, which doesn't always happen, and it'll be interesting to see.
What comes?
It's hard to fight my natural tendency to not believe anything in a probable cause affidavit.
Something's going to be there, and more. There's more to come. There's going to be a lot more to come. But it's. I think what's impressive about this case is the digital work, like the data driven police investigation.
Yep.
Which a lot of places struggle with. And they
did a good job bringing the FBI in right away.
That was the smartest thing they did.
I think it, if anything, it might scare someone in the future knowing, like, people don't see the everyday policing behind big cases.
Everything's on camera. Yeah. Everything is being tracked. Your phone is a resource of a lot of things. And I think that's going to come out. We'll have to wait and see what happens with it. It'll be interesting to follow. But now that we're done talking about murder and death, we're going to switch to something hilarious, which is
our quote of the month.
Yeah, we have a list, and we try to get them to fit. This one doesn't fit anything. Well, no, it kind of does.
Neither does it.
Because think about it. The suspect, PhD candidate, supposed to be smart.
Yeah, maybe this is what he said.
Supposed to have high intelligence. Right?
Nice.
Thank you. And the golden quote of the month. We need you to bring your acting to this because this comes from a sassy, allegedly impaired, youngish lady.
Okay, let me
get in the character here.
Don't look at me like I'm dumb, officer. I have my bachelor's in law. Except for I would say I have a doctorate in law.
So, bachelor's, and that's the funny part.
Yeah, I know. That's the joke.
If you know it, there is no bachelor's in law.
No.
It's a graduate degree, damn it.
But you know what? Solid effort.
It was sassy. I enjoyed it. I had to watch it twice to make sure that's what it said.
That's funny.
Okay. Completely switching gears again.
Yep.
We are bouncing all over the place, and it's fun. Hopefully, give some things to talk about. The ultimate case, the ultimate situation of defiance in our state, the most famous, the biggest, baddest, bestest, really pretty enjoyable case to read as well, is what?
Tinker v. Des Moines Public School District.
Tinker versus Des Moines Public School District. It was a case from the Vietnam era. It went all the way to the United States Supreme Court. Yep. There are, if you go to the federal courthouse, Southern District of Iowa, there's a big thing on the wall about Tinker. I never really cared to read about it until we got into this because I honestly didn't care. But then the more I got into it, I was like, this is a big deal. Like, this was a huge case,
it's
giant
a huge case.
What generally, give us some background on it.
So you said Vietnam era. It was 1965, December, and there were high school students, middle school students, that planned a protest with black armbands to show their protest of the Vietnam War.
So let's back up real quick. How did this get? So this is a case that actually from Iowa went from Des Moines. The DSM, the Metro, went all the way to the United States Supreme Court.
Yep.
Back in 1965, it was decided. I think the facts were in 1963.
1965 is when it happened.
Okay.
69 is when
69.
the Supreme Court. So
See?
that's 4 years.
4
4
years.
years of going through the court system.
And so Tinker is the plaintiff.
Yep.
They sued. So the plaintiff is the person that sues, files a lawsuit. They sue the Des Moines Public School District.
Yep.
God bless them.
Mm-hmm.
For what?
A violation of First Amendment rights. So their argument was that by stopping them from wearing these armbands and disciplining them, it inhibited their ability to protest the Vietnam War.
Okay. So let's go back. 1965. That was before I was born, believe it or not. Well,
Same.
before you. Colin might have been close. Dope Yoda might have been close. Actually, no. I think my parents were like 10 looking at it. Not to call them old, but they're older. What's going on? What's going on in our society back in 1965?
Civil rights movement
Okay.
and Vietnam War
So two of the biggest
at the same time.
social upheavals in American history since the probably Prohibition and then probably Civil War before that.
Yep.
It was a hot time.
Yep. And civil rights movement came protests, and protests are televised, and a lot of it had to do with young people. And so this was using your voice was in, hip, cool. That's a lot of what people were seeing. So it makes sense of why
So that
13 and 14, 15-year-olds came up with this idea to wear an armband to school.
So what they did is these kids, high school kids, right?
Yeah.
Middle school to high school, had this idea that they were going to wear black armbands in protest of
The Vietnam War.
in the Vietnam War as kind of a memorial for the soldiers that were dying. And I mean, we look at this now and say, I mean, what's the big deal? I mean, it's well-intentioned. They're just wearing something to show symbolism. Hell, I mean, we've had an entire sports industry completely change their uniforms now to address some social issues as well. So what's a black armband? But what was the authorities, since we're talking defiance, what was the authorities' response to learning that these kids dared to wear black armbands?
So it's actually interesting when I was looking into the background of the case, the situation in which the school officials found out about it. They were actually in a meeting because someone on the newspaper in the journalism class wanted to write a paper about it and had asked permission with the teacher. Teachers talking about it with other officials, and then they get word while they're in this meeting, very dramatic, that they're going to wear black armbands. I know. So what did they do? They pass a school rule that says no black armbands.
What about blue armbands?
Yeah, that's fine.
White armbands?
Yep.
Oh,
I know.
can't do that.
Just not the black armbands.
Okay.
So
In the theme of defiance, tell me what our kids did.
on December 16th, they went to school and they wore their black armbands.
Damn Skippy.
Yep.
And what happened?
And they got suspended.
Booted.
Booted.
That's not cool.
No.
Okay. What's at the end of it?
So they appeal it to the school board.
Mm-hmm.
They bring a bunch of their friends.
Yeah.
I actually found pictures online of them all sitting in the school board hearing.
Cool.
They don't do anything about it. And so they lawyer up.
Damn right.
Yep.
Time to go.
And lawyer says, go back to school without the armband because we don't want to complicate this with truancy issues.
Mm-hmm.
Also, it's going to take 4 years apparently to get through the system. So
You don't
need
want
to
to
keep
miss
going
out.
to school.
Right.
Lawyer up, filed suit in federal court. The Tinker siblings' dad filed it on their behalf, and that's how it all began.
And the kids that were involved in this case, they actually still live in Des Moines.
Yeah.
I mean, they're no longer kids.
I did some research on them, and one of the most interesting things I think about their past, a few things, but they were close family friends with a woman named Edna Griffin. And it's State of Iowa v. Katz Drugstore is the case. But she was it ended up being a criminal case. But basically, she was big into civil rights. Black woman denied service at an ice cream shop. The waitress asked for their order, took the order, went back. Manager said, no, you can't serve them. And then went and told them, we don't serve Black people. So she lawyered up, and she had already successful got to the Iowa Supreme Court. Mm-hmm. And they held that you can't, based on race, you can't deny people services. So that's like their upbringing was in and with and around this family, which I think is interesting.
A group of defiant heroes.
Yep.
Because like every case has to have that person that's willing to take the stand and then take a beating, kind of, so to say, in order to be able to get the case where it needs to go to say, no, you can't do that.
Yep.
So they appealed it. What did the Iowa? So actually, it went to the Iowa Supreme Court.
No.
Then initially,
they filed it in federal court.
Yeah.
District court said it was not a violation.
Hold on, I gotta say this.
Okay.
I was wrong. You were right.
Yeah.
Southern District of Iowa.
Southern District of Iowa. I think they said it was not not a violation of the constitutional rights, and then went up to the 8th Circuit.
Our friends of the 8th Circuit.
Yep. They had, usually the appeals court is only 3 judges at a time are hearing the case. They had 8. One was not there.
All of them.
Yep. Affirmed the district court decision without an opinion.
So said that was correct. Good to go.
And then they appealed to the United States Supreme Court, and they accepted it.
Which is, I mean, that's a big deal.
Yeah.
There's very few. I mean, it's on our checklist. If we ever get a case up there, then we get to we'll have a group trip to DC, I guess, and have a party. But that's a big accomplishment just to get there.
Yeah. Lawyer was fresh out of law school too.
No joke.
Yep.
That a kid.
Mm-hmm.
See the defiance. Oh, I love that.
Yep.
I love it. And so what happens? Supreme Court, hear ye.
Supreme Court. I think the craziest part about the whole thing, Supreme Court says that students are persons under the Constitution, and they do not leave their constitutional rights at the gatehouse.
You know what's funny is nowadays we're like, duh.
Yeah.
Duh. Back then, that was a big deal for kids to be recognized as having constitutional rights.
Yeah.
And to be able to exercise their constitutional rights.
Yeah.
That was a big deal.
And in school.
Yep.
Like, schools aren't also something they say, but schools don't have 100% authority over children. They might have.
Back then, everybody was like, no, the schoolmaster can whomp you, can spank you, can tar you, can feather you, can do whatever they want.
Yep. And so this was really like the first limitation of like, wait, you're not actually completely dominant over these children that are in your school district.
So kids have rights.
Kids do have rights.
And one of those rights is?
Freedom of expression.
Okay. And so how is wearing a black armband expression?
So speech is not just speech. Speech is to normal people. It's just talking.
Right.
Speech in First Amendment terms is something expressive of an idea, adds to the marketplace of ideas, political ideas, political protests. Those types of categories of speech are the most protected speech. Symbolism. And so what they were trying to do was put on a passive, expressive protest.
Okay.
And limiting it was a violation of their right to be a part of society, really.
So the Supreme Court, United States Supreme Court, smacked down Des Moines Public Schools and said, you can't limit, A, children have rights.
Yep.
B, you can't limit their exercise of a right in an unreasonable manner.
Yes.
What's the standard?
So your speech cannot materially disrupt the classroom or not punishment. Why can't I think of the word? Discipline.
Okay.
Discipline in schools. Can't materially disrupt them. Second one is that it can't intrude on the rights of others, students or teachers.
Okay.
So materially disrupting has to be real.
Mm-hmm.
There has to be a real,
not make believe,
a real threat that chaos might happen at the school. And then, of course, interfering with people's rights is bullying, harassment, threats, specifically targeting. But in this case, they were doing neither of those things.
Yeah, minding your own damn business, wearing a black armband as a symbolism, fine, okay. That's pure expression that doesn't harm anybody else.
Yep.
Just because you may not agree with what they're expressing, you got to be able to take it.
Yep.
Okay. My favorite part, though, can we talk about the dissent?
Yep, I knew you would want to talk about this. You're going to have to read some of your quotes.
So it was not without a few dissents.
Yeah, it did have dissents.
One justice was like, well, I'm not really sure I'm ready to give students all the same constitutional rights as grown-ups. But then Justice Hugo Black, he is actually, if you look him up, even Wikipedia, but past Wikipedia, he was actually a former member of the Ku Klux Klan from Birmingham, Alabama. Now, when he was a Supreme Court, he was, especially early on, he what do you call that? Publicly denounced his involvement in the Klan.
Okay.
And he actually had some really good rulings related to civil rights and that kind of thing. As he got older, he got grumpier.
That happens.
And Tinker came along. He was pretty much at his grumpy stage.
Okay.
And he had zero patience for the thought that kids could tell grown-ups what to do, or that grown-ups did not have complete and utter control over kids.
Yep.
He was not happy. And he put it in words. And in fact, at the beginning of his opinion, for no reason at all, it has nothing to do with how the case was decided, he made it a point to throw some shade at the Tinker kid's dad.
Yep.
He made it a point to say, and I'm guessing back then, this was kind of like this was offensive.
I'm sure it was.
He made it a point to say that their father is a minister.
Without a church.
Without a church. How dare he?
Jail.
And then he goes on. At the end, he had a lot of good quotes. At the end, he says, "This case, therefore, wholly without constitutional reasons in my judgment, subjects all the public schools in the country to the whims and caprices of their loudest mouth," now he really gets after it, "but maybe not their brightest students."
Welcome to the world.
Hugo nailed it. But Hugo had to deal with it. It's a changing world, damn it.
The dissents of throughout history, watching big changes happen, it's always kind of funny to look back on them.
Kicking and screaming.
Yes.
Matter in hell.
Not gonna let it go. And it's always just like, there's no reason why this is constitutional, and then just go on to something. And
these whippersnappers.
Yeah.
Telling us what to do. We're telling them what to do.
So that was the beginning of students' freedom of expression.
Students having rights under the Constitution.
Being persons.
That could be enforced under the Constitution. And it kind of highlights what we're going to talk about this episode and next episode, which is this overarching theme of arrogance, government arrogance, and especially in school districts and in the school systems, they have I'm not going to lie, teachers have an impossible job to do, but sometimes the poop sandwiches that they get handed from administration and from the legislation makes everything that much more difficult for them. And so we're going to dive into some of this stuff.
Yeah, we are.
And really get after. We're talking about taking corporate punishment back at schools. We're going to spank some schools and talk about it.
So post-Tinker, truthfully, what do they do after they give constitutional rights? They walk it back a little bit.
Do they?
Always, yeah.
Okay, you've been waiting for this one.
Yeah, I mean, this is one of my favorite, cases throughout all of law school. So, of course, we had to talk about it.
Talk about it.
But so after Tinker, they have rights. You can have a freedom of expression. You can protest the government. 2007 case, United States Supreme Court came out of Juneau, Alaska.
I've been there.
You have.
Last
you
year.
Have.
Beautiful place.
I would love to go.
It's worth it.
Yeah.
Yep.
So high school student is a class clown, I would say. They're
Defiant.
They're having a school assembly type thing. Why? Because the Olympic torch relay is going through right past the high school.
Okay.
So the whole school is outside. Administration's outside. The cheerleaders are cheering. The band is playing. And the cameras, the news cameras are everywhere. So as soon as a news camera is on the petitioner, who's Frederick is his last name, him and his friends open up a 14-foot banner. What does the banner say, you ask? Let me tell you.
Hold on. What does the banner say?
Bong hits for Jesus. So,
what harm is that?
The principal sees it, and the principal walks over and says, take that down immediately. And everyone does except for Frederick. He just stands.
Can you, like, I have this scene in my head. This
Oh, just absolutely runs in between
huffy,
people.
like gonna get ran over by the torch if she's in the way.
Absolutely.
You take that down, Frederick.
Yep. So he doesn't do it. He doesn't drop it.
Defiant.
She takes it from him, confiscates it, takes him back to the office, suspends him for 10 days. He ends up doing an 8-day suspension, but he ends up filing a 1983 action, which we're going to talk about, saying that she, for confiscating and disciplining, has violated his First Amendment rights.
Frederick read Tinker.
He did, or someone did. So
it's funny as pot's legal in Juneau now.
Interesting.
I think, yeah, Alaska has.
Huh.
Yeah.
Yep. I mean, the world changes.
Probably not for high schoolers, but
at this time, I don't know that legalization of marijuana was really
wasn't
thought
a thing.
to be
a thing. Not coming
in the future. But the United States Supreme Court held that they, in a school-sanctioned event like this, where the whole school is there, they're getting attendance for being there, the cheerleaders, the band, all of it makes it look like the school is promoting illegal drug use. So they said that this did not violate Frederick's constitutional rights, and the school was free to limit speech promoting drug use.
Okay, so black armbands, okay.
That, yes, political speech, protests of the war.
Bong hits for Jesus or Jesus.
We don't know.
Don't know.
That would be
disruptive.
Okay.
Does it matter if it's on campus or off campus?
It does.
How so?
Well, the limits are fairly new.
Okay.
By the limits, I mean there are no limits yet.
Okay.
But it's a fairly new question. In the United States Supreme Court last year in 2021, case called Mahoney Area School District, BBL.
Is this the cheerleader F-bomb case?
That's where the United States Supreme Court said that schools do potentially, in limited circumstances, have an interest in regulating speech off of campus.
Really?
Yes.
Okay. But give us a little bit of background on this cheerleader F-bomb case, because we can't just say cheerleader F-bomb case and not talk about the cheerleader F-bomb case.
So, public high school in Pennsylvania, and the high school student tried out for the cheerleading squad, and she also tried out for her desired position on the softball team. She did not make either.
Happens. And
she got a offer to be, job offer, an offer to be on the JV cheerleading squad.
Unacceptable.
She was mad, and she just absolutely broke in the middle of a gas station, and she posted a Snapchat story, and it said, fuck this school, fuck school, fuck softball, fuck everything.
That's expressive.
It is expressive.
Off campus.
Yep.
But she uses the word school.
She does.
And a sport in school.
Yep.
Okay.
So the
kind of disruptive, but it's a Snapchat story.
Yep.
They
So
disappear, right? All the time.
Snapchat is limited to people that you add on Snapchat.
Mm-hmm.
And it was a Snapchat story.
Mm-hmm.
And someone screenshotted it.
Jerks.
And
there's always that one person.
And you know, what do you think they did next?
Told their parents.
Told their mom. It's always same story. Mom was the cheerleading coach.
Oh.
So,
coach's
they basically
daughter.
rescind their job offer on the JV squad.
No JV for
No
you.
JV. And they say that she can't be on JV, and reasoning because it was made people upset. The cheerleaders were upset. Oh no, what are they ever going to do?
Mm-hmm.
And she appealed it.
And
it was a violation of her First Amendment rights.
so we can drop F-bombs.
You can drop F-bombs on Snapchat in a gas station when you do not make the cheerleading squad.
To me, that makes sense.
It does.
That's first of all, I've tried to tell my parents this. I'm looking at them. F-bomb has some literary and emotional.
No doubt. I mean, it's like a normal part of my vocabulary.
It is expressive as fuck.
Good one.
Thank you, dad joke. But it absolutely is, and there's no threats. There's no interference with anybody else.
Nope.
She's not disrupting class or the torch parade.
Yep.
Okay, good for her.
Yeah. So they said that schools might have regulatory interest in some of the speech that happens, and they did this for good reason. Some of the things that they outlined that they would have an interest in disciplining.
Ooh, they gave us a possible by the way.
Severe bullying.
Absolutely.
Harassment.
Yep.
Threats aimed at teachers and students.
Fair.
And failure to follow rules concerning lessons, writing a paper, use of technology, plagiarism, talking to your peers, cheating.
Disruptive behavior.
Yeah. Disruptive to the school. And their job is to teach you, and some might argue that cheating doesn't teach you much. Others might argue differently.
So let's put this in a different context. If she were running down the hall during school hours yelling, fuck this school, all that.
That's disruptive.
You're going. You're not going to win.
No.
Okay. So takeaway on that case, and really our First Amendment takeaways are you have every right to express yourself.
Yep.
To speak your thoughts, to promote your what you have going on, and what you believe, but you can't interfere with other people.
No.
That's kind of the overall theme.
Yeah. And they still can limit your ability to talk in class.
Sure.
Time, place, manner restrictions, right? They're not coming at you saying, hey, we don't like your message with this black armband. We're going to ban that. They're saying, hey, we're in the middle of class right now.
Shut up.
Yeah. You can't actively, you can be defiant, but not too defiant.
Okay. You can't be you can't mess with other people's right to learn.
No.
Yeah.
But you also, as a high schooler, middle schooler, elementary school, your opinion matters. And that's basically what their holding in Tinker was these are intricate parts of our community, our society. They're the future. They deserve to have opinions just like we do.
Perfect. That's good. That's some good takeaways. Are we done with schools yet?
No, we're not done with schools yet.
No. What's next?
Well, what's next with schools is a do's and don'ts with Donut that we're going to transition into. Are we doing that after? I think we do it now.
I think we're doing that. Are we going to throw that now? We're
going
to do we're messing up with do's and donuts.
I think we start with the do's and don'ts because it leads well into our next topic.
You're the boss.
Okay. And everyone needs to do those with Donut.
We do.
It's funny.
And I know a little bit about this, but I don't know it all.
Yes, we'll go with it. Okay. Title.
Sip of my fake beer.
My 13-year-old daughter was sent an unsolicited nude photo, and her school is treating her as the offender.
We haven't dealt with anything like this before.
Never.
Never.
Foreign concept here.
Yep.
My daughter is 13, and she was called into the principal's office today over the fact that she told a friend that she was upset because someone sent her a nude photo unrequested, and that friend reported it, as she should. As far as I'm concerned, my daughter is the victim of a sex crime in this instance.
True.
The nude photo was apparently a young boy that's in her class. The principal asked about the photo. She showed him, and he took her phone, wrote down her password, and proceeded to look through all of her texts and photos, including those between family and friends. She never sent it to anyone else. She didn't ask for it to begin with. But they interrogated her like she did something wrong, and they ended up doing this to multiple other students who also received the photo. They did not contact any parents, and the only reason my wife found out was she was picking her up from school early because our daughter had emailed her that she was having a panic attack. When I met with my daughter, she's bawling and said she was scared to death that she was going to be arrested because of how strict they were acting. Principal yelled the entire time, blah, blah, blah. Do I get a lawyer for this situation is the wrap up of the question. So, Bobby, if someone sends someone an unsolicited naked picture, can the principal just take their phone?
If they let them.
If they let them.
If they let them. And this is my biggest pet peeve of all time as it relates to schools, parenting, children, social media, all wrapped into one ugly shit sandwich. Mm-hmm. It's terrible. It sucks. And I'll add, schools suck at, by and large, are terrible at investigating because they have that mindset of we control, you do what we tell you, or else. And schools administration especially, puts themselves in such a terrible legal position by doing exactly what that principal did. Yep. Lawyer, that in that situation, gloves come off.
Yeah.
You're going to feel some defiance because we've been through this 100 times. Is your phone protected?
By passcode.
Okay. Do you have an expectation of privacy in that contents of your phone?
You do.
According to the United States Supreme Court even.
Yeah.
It's protected. You don't, and the important thing, especially what I really want people to understand, you're exactly right. This is the perfect segue into the next section, which is public schools, especially government-funded schools, are government actors.
Yep.
Okay? That is the state acting. They're the same as law enforcement to a certain extent, which means the Bill of Rights, as it's created, is created to protect citizens from unreasonable government intrusions into their constitutional protections.
Yep.
Private schools, completely different story.
Yep.
Completely different story. But public schools, they might want to have a special, civics lesson for administration on what the Bill of Rights are.
For real.
And what they cover.
Yeah.
What are your takeaways?
Okay, well, first of all, one of my first thoughts is, you freak. Why are you pulling a 13-year-old girl into your office to look at child porn? Freak.
Yeah.
You're a freak.
They didn't think
Red
that way.
flag right away. I know.
True.
Yeah, they didn't. I'm sure they didn't think about it.
Now you're a government actor. You're a state actor, and you have actual knowledge of the existence, the creation.
Yep.
The production, the creation, the possession, and the distribution of child pornography.
Yep.
You're in a really shitty situation now, Mr. Principal.
Yes.
Or Miss Principal.
Yeah. And second thing is, that doesn't lead to looking through someone's entire phone.
No.
Clearly, she told them the passcode. What 13-year-old's not going to?
Mine.
My future child.
They
probably.
get taught that the
Fair.
minute they can
Okay.
talk.
Most people aren't.
Some people read books to their children before they're born. I read the Constitution.
Get a warrant. Get a warrant. Get a warrant.
Fourth Amendment.
But I mean, it's like a traumatizing experience, and I think that the parents have every right to be mad about it. I would be. you should be upset when your young child is taken advantage of or unfairly treated. It doesn't seem like this girl did anything wrong, and she kind of got stuck in the fray.
The 13-year-old who took
Yes.
and sent the wiener picture, I'm assuming,
Problem.
commits if he's an adult, it's a felony.
So
it's a sex offense.
Do you want to know what you find out in the comments of this Reddit post?
Oh, yeah.
It's the son of the principal. Mic drop.
Mic drop. Call me. Yeah,
Yeah.
I mean, that's, yeah, okay.
Yep.
Bye.
Yep. So
Okay.
that's a good one. For your own personal benefit, too. You're not even just missing out on your civics lesson here.
Oh, my God.
Mm-hmm.
And then to pull the victim, out of class
Victim of your son.
of your
Yeah.
son into the principal's office, and then you victimize them further by searching the entirety of their phone.
Mm-hmm.
And this is another big area where schools screw up all the time, not contacting parents at the
Yep.
first opportunity. Like, you can't, like, kids are kids.
Mm-hmm.
They're under 18, especially under 16. Parental notification is a prerequisite to
Yep.
doing anything substantive really with a child,
Yeah.
especially going through there. And so that brings us to, that's actually the perfect segue.
I know.
You killed it. Good job. Always.
Not always. Sometimes.
No, well, yeah.
Yeah.
Expectations of privacy, and this is a different type of a constitutional interest is
Yep.
protected in schools, though.
Yeah.
So phones,
Phones,
lockers, desks,
backpacks,
backpacks,
cars.
This is a super interesting area because Iowa actually has a law that's created by the legislature.
Yep.
Now, we know what we think of necessarily all their legislation around here. Just because they make a law doesn't mean it's constitutionally correct.
Yep.
But Iowa has a specific law that is actually pretty good, that says that limits, that first of all breaks it out and says, listen, kids do have an expectation of privacy in their personal property while at school.
Yep.
And there are certain restrictions on the school and school administration on interfering with those privacy interests. And it really depends on the type of privacy interest that exists,
Mm-hmm.
and then what they're looking for and how they're looking for it. But what if you're looking at this and saying the school search issue? What are your big questions or concerns about school searches as it relates to students?
I would say, what are you searching for?
Mm-hmm.
That I feel like is the biggest line.
Okay.
In my mind, not like saying like legally, but
Right.
that would be my thing is what are you searching for? Does the potential risk outweigh the potential reward of what you're finding,
Mm-hmm.
their children? Yeah.
You mentioned, so, and it's interesting because when we started to look into this,
Mm-hmm.
Kids do have expectation of privacy in their personal property, in
Yep.
their phones, in their cars,
Yep.
in their bags. That is the most protected area of personal property on campus.
Yep.
Lesser so with lockers.
Yep.
And in general, I think the easiest way to sum it up is, one, the school has to have a written search policy.
Yeah, and they have to follow it.
They have to follow it. If they don't follow it, they're in trouble.
Mm-hmm.
2, what they can search and when they can search depends upon the item.
Yep.
So lockers and school property, there's a lesser expectation of privacy for students in that. There has to be notice still given. There still has, or like it has to be a general policy and procedure
Yep.
that the school's furthering. But as it relates to personal property like phones and cars, you always have the right to withhold consent.
Yep.
Always. And if they're going to search it anyways, they're going to search it anyways. Guess what they're not going to do with your phone if it's password protected?
Get into it.
They can't search it without your consent, period. Cars, obviously, they can take action. but they have to have some reason to believe that the search is going to uncover evidence of wrongdoing, either crime or a
violation of school policy,
violation of school property. So we could get into drug testing, alcohol testing before prom and dances and all of that stuff. We're not going to have time. Yeah. And maybe we have to circle back around to that as well.
Moral of the story, though, is that they can or breathalyze you before prom, potentially drug test you with athletics, right?
Athletics, extracurricular activities have lesser protections. It has to be a neutral, kind of randomized or based upon a suspicion that they can identify. But I think, so we said that at the beginning that we would leave with action points.
Yep.
Okay. Action point number 1 is what?
Use your voice.
Use your voice. Speak up. Stand up. You can have a little defiance. It's okay to be a little bit respectfully defiant.
Yeah, that's a good one.
I like that. Step 2, though, is preemptive education.
Yep.
Parents need to talk to their kids about how to do it, what to do, what their rights are, and what is going too far, and when to stand up.
Yep.
And then I think an important one that a lot of people overlook is they get a freaking handbook every year.
Yeah.
That handbook is the Bible for school. And it's going to guide what the school can and can't do to most extents. And a lot of times administration hasn't even read their own damn handbook.
That's not surprising.
So if you get in there, you review your handbook, they have to have a written search policy. If there's drug testing, that has to be in writing. And it'll explain the complaint process and that kind of thing. And, you can't single specific students out without some type of reasonable suspicion that they're doing something wrong. You can't just be like, Sydney's kind of a bad apple. I'm going to go search her locker.
Yeah.
No, you can't do it that way. You can't pick on kids. You can't pick on students. And if worse comes to worse, this is a teaser for the next episode, is there are remedies in court. You can sue the pants off a school district. Yep. You can sue the school district for violating rights. If they don't respect it, if they want to be arrogant, you can bring them to their knees.
You can.
If you do it right.
Yep. So lawyer up.
Lawyer up, baby. All right. That wraps up season 2, episode 1.
Number 2, we'll be back with part 2 of the educational rights.
How to bring the arrogant government.
How to be respectfully defiant with a lawyer in court.
There you go. I'll do that one.
Something like that.
Yeah. We'll take it. All right. Cheers.
We can't change the past, but we will change your future. GRL Law. Thanks for tuning in to GRL Raw. Check us out at grllaw.com.